What are the top 3 mistakes that a healthcare attorney has seen over the past 10 years? Let me tell you in this video. First, confidentiality breaches. Second, we're going to talk about labor law compliance and the use of contractors. And third, it's going to be working in and not on your business and how that leads to downstream legal issues. So first, let's start with confidentiality. So confidentiality in a healthcare business, everyone thinks about HIPAA, but there's also state rules. And also there's a huge misunderstanding for what HIPAA is, when it applies, what to do, all of that. So at the end of the day, when I see a traditional HIPAA breach, what is happening is it's usually a staff member. It could be a marketing campaign. It could be a staff member that wasn't trained very well and just has kind of loose, gossipy lips and went out in a more social setting and started talking about a certain patient. The key points in how to prevent these is you need internal HIPAA policies and procedures. This isn't just the notice of privacy practices that you give to the patient that no one actually reads or understands or actually truly understands what is going on. It's the internal HIPAA policies and procedures and associated state law rules if they exist. So what does that mean? What does that look like? It's about maybe a 60 to 100 plus page document that says exactly what HIPAA is and or state privacy rules are, what they are not. Is there a breach? Which is, you got to start with that. We don't assume everything is a breach. Did HIPAA even apply in the first place? Maybe not. Fun fact, HIPAA does not apply to a lot of transactions that are going on out there. So if there is a breach, we need to determine who, if anyone, we need to report to, which is generally determined by how big of a breach it is. And then in that internal policies and procedures, it's nice, and the ones that I draft or have available, it is going to have sample notification letters to the patients. You already have all of the tools that you need. You don't need an attorney. That's nice, not necessary. But if you have those internal policies and procedures, even if there's a breach, even if you screwed up, as long as the policies and procedures were followed, and this was an isolated incident, for example, you sent out a mass marketing email and you CC'd everyone instead of BCC, or you did have that rogue staff member that went out to a restaurant or a bar and started gossiping about this procedure that somebody got, and oh my God, they're a celebrity, this and that, right? As long as you're following your internal policies and procedures and you have them in the first place, the Federal Department of Health and Human Services is much more reasonable with working with you and not assessing fines if you can show that you can self-regulate. Now, if you panic, you never even had HIPAA policies and procedures manually, you don't even know what that is, and you are not taking any corrective steps or, in effort to move towards that category, that demonstrates to the government and really, I guess, attorneys that you don't know what you're doing, you can't self-regulate, and you really can't be trusted. And so that's when we fine and potentially take other legal action against these providers. Fun fact related to confidentiality as I close it out is that under HIPAA, there's technically no private cause of action written into the law. Now, some enterprising attorneys have figured out ways around that, where using state law or using HIPAA as just a general negligence standard. So was it reasonable with the breach? Were you unreasonable? And the biggest issue with these types of actions is, what are the damages, right? So yes, it's embarrassing. Yes, your information is out there, but what are the actual damages? In the unique cases where these are brought to trial and there's, multi-level or multi-figure damages, usually there's one more step, like an X or something that we can show as downstream damages. But that's an aside. Moral of the story, we need internal policies and procedures so you know what the heck HIPAA is and is not. And therefore you can train yourself and your staff and also have the associated and respective state law rules if they exist. Second top mistake, general labor law compliance, which has gotten extremely, the stakes are much higher in 2024. There's a lot of labor law rules that are pushing the use of independent contractors effectively out of existence. And one of those is a recent rule with the U.S. Department of Labor, which is under scrutiny, but will probably stay regardless of if it stays with both state and federal law. You need to know the difference between an employee and an independent contractor. They are very different things. An employee, traditionally, W-2, you can control them, you do their training, you tell them when they can and can't work. you're really investing in them long term, and they're probably not working elsewhere, at least during the term of your employment with them. Independent contractor, on the other hand, think of them as a hired gun, like a pilot back in the day that's going out and, doing tasks for you. Truly independent, and they can work elsewhere. They do their own training, that's a big one. They use their own software, sometimes difficult in healthcare settings because of EHR and billing. You need to be using the same software, but generally they're using their own materials, like computers, doing their own marketing, things like that. They are able to work elsewhere and market themselves, moonlight, work multiple jobs. You're not controlling exactly when they work. They can only work for you. Two very different things. The temptation for any small healthcare business owner, which I respect, is to use independent contractors because they're easy. You send them all their money, they figure out their own taxes. The payment structure is very clean, and most small business owners are generally afraid of employment, which at the end of the day isn't that bad. If you're in a dilemma and you're weighing all these pros and cons, trying to figure out, okay, well, contractor versus employee, I got all these decisions to make, the safe legal answer is always going to be employee. Because I think if you really drill down to the core of why a small healthcare business owner is not hiring employees, it's because they're afraid of the employment rules and that they're going to do it wrong and that their employees are going to cost more and sue them for all these unique labor law protections. And it's really a fear-based argument rather than being based on a more structured and thought out pro and con. So, end of the day, especially with enforcement moving pretty aggressive against independent contractors at the state and federal level, employees are going to be the end game, and misclassifications can have fines and all sorts of downstream issues. And if you really price it out and you really get down into the nitty-gritty details, I doubt that you are saving that much money doing an independent contractor. It's really just more easy to do the math, and that's what's really going on. Finally, third big mistake that leads to all sorts of different legal troubles with a small healthcare business, worst ones I've seen over the past 10 years working as a healthcare attorney, is working in the business, not on the business, which is, it's very cliche. What it means is that you're working in the business. You are doing the therapy, you're doing the medical procedures, the visits, the actual nitty-gritty day-to-day operations, right? Which need to be done. And at the very beginning, it's probably just you as a small healthcare business owner. But if you are only going to work in the business, there's always going to be a cap to, first off, the revenue that you can make if it's just you and the hours you can work in a day before you're burnt out or, fighting with your spouse, not seeing your kids, not having hobbies, not seeing your friends, having a whole host of mental health and substance use issues. You need to be working on the business. So what that means is having a business plan on quarterly, yearly basis on where you're going, how you're going to delegate some of your tasks to other people, especially administrative ones. As a skilled licensed professional, you should, in a perfect world, only be doing the most skilled procedure that you're licensed to do. So for a medical doctor, let's say you are a plastic surgeon and you're, doing facelifts, you should only be coming into the procedure, doing the facelift, going to the next one, right? And maybe high-level patient communication. Outside of that, all the business stuff, the working on the business, would be getting everything else into the hands of other staff. That could be virtual executive assistants, it could be medical assistants, nurses, other types of staff, accountants, business professionals, marketing directors, intake specialists, whatever. Not you being the one that's doing everything, every email, every phone call, every little mini business decision. So charting a path for how to work long-term for where this is going, so you are doing more high-level decision-making. Here's where this turns into legal issues. So you open up this healthcare business, you're doing great, you're starting to make revenue, you feel like you finally made it, but you've entered into this trap where you're so focused day to day on all these nice medical appointments that you got, which is great. You're getting revenue, your name's getting out there, it's being successful. But here's what happens. You forget about core business operations that then lead to legal issues. These could be, you don't have a good workflow for how to follow up to patients, especially, things that, that's nice. We should get back to that patient and tell them about that, but it's not really what we do. The lack of having a system in place means that email or communication sits there for weeks or even months, or you don't even forget it. Patient gets upset, files a board complaint, or, oh my gosh, you were supposed to follow up with the lab that was sent out. For some reason that was done. The lab didn't get back to you. Patient, turns out, was, positive or what have you, needed to get follow-up care. Now they have damages against you and it wasn't a very reasonable timeline. These could have been solved by you working on the business on your workflow. That's an example. Another one is you're just so deep into the patient work that you are not supervising other staff appropriately. So you have staff that are doing a little bit of what you told them to do under a supervision plan, but since you have close to zero time to mentor, supervise, develop, build the internal protocols for the company, they're going a little bit rogue on their call scripts and they're getting a little chatty and they're starting to blurt out patient information all over the place in public spaces. They're leaving voicemails with very detailed protected health information that we don't know if that's necessarily going to the actual patient or if a general line or a general email, what have you. And because you're not working on the business and keeping an eye on these internal protocols, inevitably this leads to legal troubles. Usually, what I mentioned in number 1 with the confidentiality or HIPAA breaches. If you're interested in content like this, please like, follow, share. Happy to share more free tips like this.